All right. Good afternoon. Thanks for joining us. This is Eric Hauge, Executive Director of Homeline, and you're joining us along with Homeline's Managing Attorney and Tenant Hotline Director Mike Bra on Wednesday, July 22nd at 1:30 in the afternoon for another one of our COVID-19 tenant-landlord related legal issue webinar. Beginning last week, we did kind of combine our two weekly webinars that were on Wednesday for tenants and advocates, and then Thursdays for landlords and property managers into just one longer 90-minute, up to 90 minutes. We don't have to take the whole time, but we might today, just with all the questions, into just one weekly webinar that will be on Wednesday. And we'll continue that into the next week as well, and we'll talk about that in a minute. So just a reminder that what Homeline is, we are a statewide nonprofit organization. Our main program is a free and confidential tenant hotline that any renter can contact us and get free legal advice about their specific situation. And we have language lines specific to English, Spanish, Somali, and Hmong languages. I'm gonna let Mike talk a little bit about this, but just briefly, our next week's session again is going to be up to a 90-minute presentation and seminar with Q&A too. And we'll again combine, and we probably for the foreseeable future will be combining into a weekly webinar just to do it all at once and potentially have other future guest speakers like we did last week. We had 4th Judicial District, Hennepin County Housing Court Attorney Melissa Hoteling on to discuss the court's plan in Hennepin County to deal with housing related cases now and into the future as the potential suspension begins to lift.
Just to clarify that, Eric, you said attorney. There was referee.
Sorry, referee.
Right.
Housing court referee,
Mm-hmm.
Melissa Hoteling. And I'll put a link in the chat to the recording from last week because it was pretty informative. But next week we're going to also have a guest speaker, and I'll let Mike, I'll pass it over to Mike now.
Sure. Yeah, next week, attorney Kim Tennyson, who represents landlords predominantly in landlord-tenant disputes almost exclusively, as near as I understand it right now. Known Kim for quite a while. She was a volunteer in our office several years ago, and she is now representing landlords, and she has been a frequent viewer of these webinars, and she's also offered up thoughts and opinions throughout. But she has agreed to come on and offer a landlord attorney perspective. I'm a tenant attorney, and so you might think, well, okay, maybe my views are slanted in one direction. So we're going to try to hear from somebody who views things through a different lens. She's covered the entire metro area. We've already talked quite a bit about how we're going to approach this session. We're going to talk about a couple different scenarios: tenants that just recently stopped paying their rent and tenants that haven't been paying their rent throughout the pandemic, and how landlords are approaching that and how she is advising landlords. We're also going to try to look at the future. When the eviction doors open, what advice is she likely to be giving her landlord clients about how to approach this, how payment plans may or may not work, and what she's anticipating. So I'm very much looking forward to spending 90 minutes with Kim. And we'll also, of course, answer your questions that are submitted in advance and that are submitted also day of the session. So looking forward to next week with Kim. But today we are talking about some new stuff. We'll again say where we are with the big picture items, and then we're going to get into the new executive order that takes effect on August 4th. To start, where we are right now, we've been talking about this since mid-April when we first started doing these sessions. There are 2 hurdles for a landlord to be able to file an eviction in Minnesota. There's a state hurdle and there's a federal hurdle. And the state hurdle remains in place. remains unchanged from where we were last week at this time. Nothing really substantially changes until August 4th, and that's only a minor change, which again we'll talk about in a second. But the main block to an eviction being filed in Minnesota is that the governor has said that evictions can't be filed, basically, and that's tied in time to the declaration of the peacetime emergency that the governor also issued starting back in March and has renewed every month since then. The current peacetime emergency declaration ends August 12th, so that on August 13th, the landlord could, in theory, go file an eviction if the peacetime emergency declaration is ended. How would it be ended? Well, the governor would end it, or the legislature, both chambers of the legislature. Once again, the governor is a Democrat, the House is Democrat controlled, the Senate is Republican controlled here in Minnesota. So the Senate and the House would both have to agree to end the peacetime emergency declaration to end the eviction moratorium that the governor has in place, or the governor could choose to end it on his own as well. That's one hurdle that a landlord has to get past to be able to file an eviction. The other hurdle, well, all right, we've got some news on this one. Today is July 22nd. The CARES Act, which is the federal rule that discusses and limits evictions that can be filed, effectively stops mattering on some levels on July 25th. So on July 26th, the landlord could give a notice to a tenant saying, hey, you haven't paid your rent, and so I want to file an eviction against you in 30 days. In Minnesota, they wouldn't be able to do that, though, because of the eviction moratorium that we already have in the state. So it's of note that a landlord gets past hurdle number 2, the federal prohibition, but they can't get past hurdle number 1 to file an eviction for non-payment of rent, which is, again, why almost every eviction in Minnesota is filed. Another provision of the CARES Act is that the landlord must give this 30-day notice. So let's theorize for a second that the governor ends the peacetime emergency declaration on August 12th. So on August 13th, the eviction doors open up again for a landlord to go file an eviction. I think if I understand how the CARES Act is supposed to apply, at that point, the landlord would still need to give a 30-day notice to a non-paying tenant, because the CARES Act is only about non-payment of rent evictions that are being blocked, in the cases where the CARES Act actually plays a role. So any place where there's some sort of federal subsidy, pretty much that's going to be covered by the CARES Act, along with buildings where the landlord has a federally subsidized mortgage or federally backed or insured mortgage, Fannie Mae, Freddie Mac. And so the CARES Act still plays a role. This 30-day rule might matter for a lot of landlords going forward. We've talked about this several times before. Our best guess is it's between 20 and 50% of all Minnesota rentals are likely covered by the CARES Act, and those landlords would still have to give a 30-day notice once we've sailed past July 25th and the eviction moratorium is lifted in Minnesota, which is, again, a couple things that we don't know when the eviction moratorium in Minnesota will end. The federal prohibition on evictions, there's all kinds of discussion in the media about whether the U.S. Senate and House will enact some sort of CARES Act 2 or extend things there. But to date, none of that's happened. A lot of times with legislative issues, things are done at the last minute. And so there's always a chance something will be cooked up between now and the 25th or even soon thereafter, hard to know. Keeping in mind that the July 31 unemployment federal boost also is a deadline that we're all looking at. So I think that gives the federal government more of an incentive to try to work on some sequel to the CARES Act in some regard, whether it's one-time federal stimulus, ongoing unemployment, more eviction limits and foreclosure limits. There's a lot of things covered in the CARES Act. It's not just landlord-tenant stuff, but it's certainly a key element of what we're examining here in Minnesota. Okay, let's
just a quick note, clarity on the slide. I think one of the problems with reusing some of the slides is the renewal by the governor on the state one has happened 4 times now. It started in March, renewed April,
Thanks.
May, June, and then July. So August 12th is the new deadline on the state one. And then
Good
on
catch. Thank you.
Yeah, and on the federal level, I have not been following it as closely, but I do think that the House has passed some sort of the HEROES Act that's like a CARES Act 2 that doesn't include a further extension. But of course, it'll come down to negotiations at the end, probably.
Yeah, I think looking at a first version of any of those acts right now it might be interesting, but I can't imagine that it's going to end up being what is agreed to. Okay, so now we're going to talk about changes to the eviction rules in Minnesota. This has happened a couple of times where the governor has tweaked the eviction rules, and the order we're talking about today is there's about 80 orders, I think. Right now we're up to 80 orders this year, executive orders, and this is EO, so Executive Order 20, which is 2020, is what that's referring to. 79. So this is the 79th Executive Order of 2020. And I'll be direct with you folks here today, listening in. This is not simple stuff. It's a little bit complicated. We have been looking at this change in the ordinance since it was issued last Tuesday late at night, and trying to figure out what it all means. And we're still not precisely sure about all of it, but I'm going to tell you what we think is pretty concrete, what we think is somewhat theoretical as we go through it, and talk about where we go from here with all of this. So what we have on this page is sort of a summary of what we're going to talk about for probably half an hour at least before we get into your questions today. The changes that we're going to talk about. So the first change I'll mention is that nothing in 2079 matters until August 4th. It's not the law until August 4th. This was a delayed order, executive order. I think with the eviction order, with the tweaks, I don't think there have been any of the eviction orders that delayed the start until this one. There have been plenty of the shelter at home orders, which are where we see the dial saying when restaurants can open up and movie theaters and barbers and things like that, that would announce that something's going to happen starting next Monday or whatever. But this is the first one we've seen where the eviction order was announced in advance. So there's a little time to sort of absorb it and try to figure out what it all means so everybody's informed before it takes effect. To start, there are more reasons the landlord can file evictions, and we'll talk about those reasons. There's more clarity on whether the landlord can give a non-renewal notice. There's a new requirement for evictions, a 7-day at least notice requirement before an eviction can be filed. And then there's this fact that old writs, if a landlord files an eviction in Minnesota, what they literally win is a piece of paper, which is a writ of recovery, where the landlord can take that piece of paper, it's an order from the court, to the local sheriff. And the sheriff then can enforce that writ. That's what a landlord wins on paper, is this writ. So writs that were issued in March of this year, prior to the pandemic eviction moratorium declaration, have been in limbo for months. And the order is trying to, I guess, resuscitate those so a landlord can use those going forward. But we'll talk about everything on this page in more detail. This is just sort of the introductory. Here's what we're dealing with for the rest of the pre-question and answer session today. Okay, go on to the next slide. Thank you. First thing I'm going to mention is damaging property. So I mentioned other tweaks to the eviction order from the governor. This is, in my mind, the one that matters the most. Maybe it's the only one, the only real tweak since this giant 2079. Okay, the first version, so EO 2014, said that a landlord could file an eviction against a tenant if they endangered the safety of other residents. It's really specific, a limit, other residents. That's what it limited it to. The second version, which I want to say was close to 3-4 weeks ago now at this point, modified that phrasing. So it wasn't just the safety of other residents. Now it's the safety of others on the premises. So in theory, that would mean a landlord, so the actual owner, employees of the owner, so an on-site caretaker, superintendent, managing person, something like that would be covered as well. I think even friends of neighbors or delivery people would be covered as well. So endangering the safety of others on the premises. That was the second version. That's the current law we're under right now. The new August 4th rule adds in significantly damaging property. All right, so this needs to still be a material breach of the lease. Probably. I mean, that's what the order says. There's an argument that the tenant might be committing something called waste, even if the even if the lease doesn't include that don't damage the property clause built into the lease. And damaging property is pretty unspecific, but so was endangering the safety of others on the premises. We have typically gotten one of those questions every week at least. What does it mean to endanger the safety of others on the premises? So damaging property significantly, what does that mean? Well, I think that's going to be up to a judge or a referee to try to figure out what they think significantly damaging the property means. But this is new, that once August 4th rolls around, this is part of the reasons why landlords can file an eviction. And it's not the rule today, but it will be on August 4th. Okay, on to our next slide if we could. Okay, here's another new thing. So under the governor's order, the new order, again, taking effect on August 4th, there's now going to be a notice requirement before the landlord can file an eviction of at least 7 days. Now that is longer if the lease notice period requires more notice. Okay. So this might seem really straightforward to a lot of people. Maybe if you're reading it for the first time, you'd think the same thing. And I'll be honest, our office didn't catch most of what we think this might mean until later. But again, we have been kicking this around, not just for this speech. We put together an FAQ that I think Eric has just posted as well on these issues. And we're trying to piece together exactly what we think this means. Normal laws are debated sometimes for weeks, months, years before they become laws. These aren't normal laws. This was just kind of an edict, like all of these have been, from the governor, because it's an emergency and the governor has the power to issue emergency orders. But we're trying to decipher what these things all mean without, of course, the benefit of court interpretation. Unless these go to court, we don't know what they mean. So none of these questions that we might be asking right now are even answerable until after August 4th. And even then, we're not going to be sure until judges start issuing rulings, unless there's clarification offered by the governor's office, which I think we're planning on asking for on several issues. And I don't want to get into every one of them, but we're going to be saying, hey, look, these things might need to be tweaked or refined, and we'll see where that goes. But right now, we're talking about what the actual letter of EO 279 says. So what's not in question is the 7 days question. The harder question is the notice period. So notice periods can mean a lot of different things, but there's a lot of leases, especially metro area leases, for a 1-year period, which is the start for most private market leases. Most landlords like to go with 1-year leases, or maybe a 2-year lease or a 9-month lease, aiming to end the contract somewhere in the warm weather months. A lot of those leases have a built-in notice period that is designed to work at the end of the lease. So the tenant, if they want to move out, they have to give 30 days notice or 60 days notice or something like that. And the landlord does as well. But it will actually define that notice period at the beginning of the lease. The notice period, 30 days, 60 days, whatever it might be. And there's no other notice period mentioned in the lease. So the question is that what the notice period means? Hard to know what exactly the governor's order means on that question. It's one of the things we're going to be talking to the governor's office about when we send over our concerns and recommendations. But we know it's going to be at least 7 days. Now, what I think is a certain change, which is a little bit surprising based on how the rules have been in place prior to today, is if a tenant is seriously endangering the safety of others. Today, a landlord can go file an eviction right now for seriously endangering. They don't have to warn the tenant, I'm going to go file the eviction. There's no number of days they have to do that. If the tenant is found with illegal drugs, illegal weapons, engaging in prostitution, they have stolen property they're in possession of, or there's domestic abuse. This is covered under a statute 504B171. The current rule, and in fact, the rule pre-COVID-19 was the landlord could go file an eviction right away. No warning necessary. And what I'm talking about is just starting the court case. It's not like the tenant gets thrown out that day, but the landlord can start the court case right away. Now, the new EO 2079 will require a landlord to give a 7-day notice before they file an eviction for, as near as we can tell, for any of the reasons. So this is a new buffer protection for tenants that didn't exist, even in those cases where they're endangering other people. Pardon me, losing my voice a little bit there. Eric, could you go to the next slide, please? Okay, next topic is the writs that we just talked about. As I mentioned, what a landlord wins if they win an eviction is that piece of paper called the writ. So there were cases that were filed in March of this year that were progressing as they always do until the eviction ban was put in place. And some of these cases were completely like a freeze ray was blasted on them saying, stop what you're doing. You can't enforce a writ. You can't go file a new case. So there were landlords that were actually at varying levels of the process, and some of them had already obtained a writ. So the writ had been issued prior to the enactment of the original eviction ban, and then suddenly the governor says, nope, don't enforce any of these, sheriff. And that's what the system did. They just stopped with everything. So we have all these writs that were ordered back in March and that were not enforced. And it's not tens of thousands, but there's some of them out there. The concerns about this are, in general, writs are only good for 30 days, is the basic rule about a writ. Once the landlord has issued the writ and they give it to the sheriff, they have 30 days to enforce it, or else it gets returned to the court, is how the sheriff works with these writs. So if these writs have already expired, I'm not sure what good the March 24th ban does. One possible solution the governor's office could use here would be the legislature passed a rule mid-COVID-19. This was pretty bipartisan, saying all statutorily set deadlines and expirations of things are basically on hold during the COVID-19 peacetime emergency. So maybe that would apply here. We're not exactly sure. But I think without some extra clarification, it's a legitimate question. Aren't these writs expired already? So a landlord would have to go do something else. And kind of on a, all right, if this is really what we're going to do question line of thought, how much notice does the tenant get of this? So a normal eviction process, the landlord has to serve the tenant court paper saying, hey, there's an eviction coming up. You have 7 days or 10 days until the court date, so you have a chance to prepare for court or prepare to move out if that's what you want to do. But you get a warning and it's official. You have to serve papers personally, one person handing it to another. That's pretty official. And if the landlord can't find the tenant at home twice, then they have to send one through the mail, regular mail, and then post one on the door. These look really official too. These are court papers, so they look like they matter. To enforce the writ, it's not entirely clear what a landlord would have to do right now. If they actually have a writ and the governor says this is suddenly an active writ that's been on hold for 4.5 months or whatever it is, will any notice be given to the tenant? Because there's a real chance, the way this is drafted, that the tenant will get on their door a notice from the sheriff saying you've got 24 hours to vacate. That's the normal process. That might be all the warning the tenant gets. Now, look, laws and a general ignorance of the law is almost never a legitimately satisfying to a court excuse. I didn't know that was the rule, right? But if not now, I don't know when that argument would work better. A tenant has been shielded by this law for months, and unless they're actually following along, and this got a little media coverage, but not a lot of media coverage. Maybe it will get more on August 4th, I'm not sure. But there's a chance there's going to be a couple hundred tenants, if the number's that high, where they'll get shocked by seeing a 24-hour notice on their door that the sheriff's coming back in 24 hours to remove them if they don't leave. And so some notice seems like it's fair in this situation. Normally, a notice is not required to a tenant to enforce the writ that's already been obtained because they were aware of the process. This is just such a weird time that was so long ago that tenants mentally might have moved on and think that was effectively a dead case since the landlord should have to restart. That might be a legitimate thought a tenant has. And you'll have to trust me, landlords don't really want to have to enforce a 24-hour notice. Neither does the sheriff, neither does the tenant. There's not a lot of winners in that setting because you're going to have a lot of tenants that are forced to move out, leaving a lot of stuff behind, which landlords always hate. They never like to have stuff left behind. They don't want to deal with the tenant's property. They'd rather that the tenant has enough time to get their stuff and get out. Well, the landlord could, of course, warn them. But the question is, does this order from the governor effectively mean that we might see 24-hour notices showing up on a door where a tenant had no notice of anything happening for 4 or 5 months. Okay, on to the next new issue. So another item that the 2079 threw in was that the owner is allowed to make a tenant go if they, again, they have to give a 7-day warning, obviously, and they'd have to give whatever notice the lease requires. But now we have a new reason. So a landlord can't file an eviction for non-payment of rent, or because a tenant has a dog when they're not supposed to, or an unauthorized occupant, just a boyfriend or girlfriend moving in with somebody. But here we've got a new exception. So before we had endangering safety of others, endangering safety of property, I guess threatening to damage the property or damaging the property. And now we have the owner wants to move in or their family members want to move in. Okay, so the order says that the family or the owner needs to move in. It doesn't define what that means. Could a landlord say, you know what, I'm not getting paid my rent, so I'm going to lose this place because I can't afford the mortgage. I need to move in. I give the 7-day warning under the order, and then I move myself in, and within 6 days or 7 days, and then I stay for a week. Have I done everything I need to comply with EO 220-79? And the short answer is maybe. We don't know. Family's not defined, or family members not defined. And there's no requirement showing sort of the validity of the need to move in, nor is there any kind of follow-up that the owner has to live there for a certain number of days afterwards to not just use this as a sham reason to make somebody go because they haven't been paying their rent. And so there's some uncertainty with this portion as well. There's some other questions, like I said, we're going to be submitting them to the governor, and we'll see where they go with them. But this is part of EO 2079 as it sits right now.
Yeah, and I'm just going to let you breathe for a minute and get a
Thanks.
drink of water as we get to the next slide. Just a reminder that you feel free to submit questions over the Q&A or the chat box. We'll get to them. We did get some sent in advance. We also had a few that we didn't get to from last week. But I don't think any of the ones that were sent in advance were really specific to 2079. So we'll definitely try to get to 2079 related questions and as many as we can once we're through here.
Right, thank you, and I appreciated the drink. Okay, another new rule that we're talking about. So in my mind, this isn't exactly a new rule. This is something we've theorized. We've heard from the Attorney General's office, who's tasked with enforcing all these executive orders, that this was basically the rule. But now we've got some clarity. So the old rule said that a landlord was not allowed to terminate a lease. It's kind of a vague thing. So you couldn't file an eviction as a landlord. You also couldn't terminate a lease. Okay, so what did that mean? It wasn't entirely clear. Could a landlord tell a tenant to leave today? No, they couldn't do that. That seems pretty clear because they'd have to go file an eviction if they wanted to enforce it. But the larger question is dealing with just how landlords and tenants generally interact when it comes to ending the lease and somebody wanting to end it. So if the landlord, old rules, wanted to end a 1-year contract with a tenant at the end of the year. So most 1-year leases in Minnesota don't naturally end on the last day of the lease. Some notice is required by either the landlord to the tenant or the tenant to the landlord to effectively end the contract. 60 days, 45 days, 90 days, 75 days, seen 30 days, seen all of those, but some notice is required. So summer, as I mentioned, is when notices are given. That's when rent increases are given. That's when renewals are done, because everybody, the landlord and the tenant, likes move-ins happening during the warmer weather months. So we're in that season when landlords would want to issue non-renewals or raise the rent if they were looking at changing the rent. And so landlords have been trying to give notices now, despite the eviction moratorium happening. So the question we've had since the beginning of this and asked for clarification from the governor's office on is, can a landlord give a future notice. So the eviction moratorium ends on August 12th. So today, could a landlord give a notice to the tenant to vacate by August 31, assuming that it's a month-to-month lease and they'd only need to give a full rental period's notice in most situations? And our answer has been, we don't think so. We think that that's terminating the lease, but it wasn't stated explicitly. The new language now says that the landlord can't terminate the lease or issue a non-renewal of lease. So that would be issuing a non-renewal of a lease during the peacetime emergency. So it answers that question for us. A question we've been getting routinely from landlords, and there are landlords watching today and there are tenants watching today. As Eric mentioned, we've combined this all into one session now each week. Landlords have been asking us every week, can I give a notice for the next month, the end of the next month, or for 60 days from now, even though the eviction moratorium is still in place? This question is being answered in EO 2079. No, you can't issue a non-renewal of the lease. I think there's kind of a weird moment in time where it's not certain that a landlord couldn't do that right now until we get to August 4th. Although I still think it's terminating a lease. I think this is just offering clarity and saying what the original order basically meant versus a new rule. This is just a new version saying, I think the same thing. So any of the same exceptions remain. A landlord is allowed to terminate a lease. They don't just have to file an eviction. They could also issue a non-renewal for endangering others' property damage or the 504B 171 violations, along with the family member rule that we talked about a slide or two ago here as well. Yeah, I think I want the next slide. Yep. Oh, that's it. So as Eric mentioned, we're going to go through some questions. I think we'll start with the ones that were submitted last week, and we'll try to plow through those. But then we're going to be taking ones that have been submitted. I see that we have, I think, 5 already submitted in today's session, because these are mostly specific to today, but we have some that were submitted in advance, plus ones that we didn't get to last week, partly because the referee was here and she's not allowed to answer every type of question. And so I wanted to make sure she got the questions that I thought that she could. She's not allowed to issue sort of predictive rulings on cases where I'm not limited by that. I don't wear a robe, so I don't get to rule on these things, but I can offer opinions that she wasn't allowed to as a judicial officer. So we decided to hold off on a couple of those questions. But Eric, if you want to go ahead and fire away.
Yeah, and I'd forgotten to do this, but I'm going to put a link in the chat to the recording from last week. It also has the slides, her slides,
right? The
referee slides that has some important, helpful information. But the video recording is there as well, and so I'll put that in a second. So we got some questions in advance. Mm-hmm. This one was from somebody in Fort Lauderdale, which, I mean,
well, it might be Lauderdale. We're not sure.
Yeah. Well, I mean, it's possible that they're a landlord living out of state or something, but
sure.
But obviously, we are specific to Minnesota law and the Minnesota suspension. So this person asked, how many in-person showings is considered too many?
Yeah, there's no clear answer to that. And Eric will put up our position paper that we put together on when a landlord is allowed to enter during the COVID-19 era. Pre-COVID-19, there wouldn't have been a good answer for this. During COVID-19, there's still no specific answer to how many in-person showings are considered too many. So there's really 2 answers to how often showings really occur with landlords and tenants. If a landlord wants to show the place to prospective new tenants, that usually doesn't take that many showings, honestly, because the new person that is the applicant that's looking at it likes it. They decide to apply once they've seen it, and they just take the place. So then there's no more showings after that. That's the sort of the default for most rental showings. When we're talking about sale showings, that's a little bit different animal right there. Sale showings are a lot and very sort of front loaded. So if a landlord puts a place on the market, tenants renting a single family home, for instance, and the landlord puts the place in the market, there might be 5 showings a day for a week and a half. And it's tremendously disruptive for a tenant living in a place. I mean, it just is. Pre-COVID-19, it was disruptive, especially if you've got kids and you're trying to clean up after them. The younger the kids, the harder this is. Or you've got some sort of disability, making it difficult to keep your place in show place condition, which is what landlords sort of expect when it comes to these sales. So the short answer is there's no magic number that's a limit. Now, during COVID-19, I think there are additional concerns, of course. You know, how are we making sure that the contact is minimized between the current resident and the prospective applicant or buyer, along with whoever's showing the place, whether it's the landlord or an agent of theirs. I have told landlords for years and tenants for years that when it comes to showings, that the tenant has no obligation to vacate during a showing. At least almost no leases, maybe 5% of leases in Minnesota require that, where a tenant must vacate during a showing. And so I tell tenants, look, you can tell your landlord, if you want me to be your showing agent, you're welcome to hire me for that purpose. And if you want to give me $20 for every showing, okay. That'll do a couple things. That'll make it so the landlord is more convinced that showings are serious, right? They're not going to just let everybody come in. And this happens a lot more when it comes to buying a place. There will be a lot more people just sort of browsing around. And I know that some realtors have started requiring their potential buying customers to go get pre-qualified at least to show that they're a serious contender for that home that they're looking to go do a showing for, because showings have become much more logistically difficult since COVID-19. There's just no way around that. But if a landlord wants to turn a tenant into a showing agent, make sure the place looks show place ready, and you're not there, and your kids aren't there, and your dog is kenneled up and things like that. I know landlords that actually hire tenants to do that. They'll give them a little bit of money. You know what, here's a McDonald's gift card or Dairy Queen or whatever. Take your kids to the park for an hour and we'll be done by then. And then there's other basic safety protocols. Make sure that the tenant leaves all the lights on. They have all the doors open, so there's fewer things touched by each side. Maybe you leave the windows open this time of the year, so the airflow goes currently through there. Small things like that can make everybody feel more at ease. Not just the tenant, but the prospective applicant or buyer and the showing agent. But short answer, there's no number of showings that is a sort of trigger limit that matters.
The next question, or just general area, within the current state of the housing market, is there any sort of legal premises for negotiating a new rent amount?
Another complicated question, actually. So there's sort of key elements to every lease. The first one is, who are the parties? Name the parties. The address, the cost, how much does it cost, and the length of the lease. So those four things are really you've got to have those four elements to have a lease that means much of anything in Minnesota, or really any state. And so, all right, you're in a 1-year lease that ends during the peacetime emergency, and your rent's $1,000. And the landlord says, well, I'm going to raise your rent to $1,100. Is that legal? Is a fair question. Or is that terminating the other tenancy? The other tenancy was a place for $1,000. Again, we have our four components, right? The place, the parties, the length of time, and the price. Those are really the four key components. And so our argument has been, and again, I'm a tenant lawyer, and this is a pro-tenant argument, is that a landlord can't terminate a tenancy by naming a new rental amount. And so we've had tenants that have filed complaints through the Attorney General's office, and I'm not sure that they're taking serious action on this topic because they've been so tied up with other things. I think that they view that the same way we do, that is in fact terminating the tenancy by raising the rent. So short answer is I don't think legally a landlord can do it. I know a lot of landlords are doing it still, where they're raising the rent. And like I said, I'm not sure that the AG's office is really aggressively going after that. But anyhow, we've seen it done by landlords. In theory, I think it's not legal, but in practice, it's hard to enforce right now.
All right, Zachary asks or states that a landlord is requiring double deposit and claims the ordinance, which would cap it at a lower amount, doesn't apply. This must be in Minneapolis, because although they manage the property, it is owned by someone else, and so those units wouldn't be included to their total number of units managed in addition to units other other units they own, keeping it below 16 total. Does the 16 unit rule apply to landlords who manage property owned by others, or only to the units they own?
Yeah, not exactly the topic today. What Zach is writing about is, in fact, a Minneapolis only ordinance, which is very confusing for a lot of people listening. It truly is just the city of Minneapolis is all this is relating to right now. And there's a staggered implementation date of this rule. Most of Minneapolis, well, a lot of Minneapolis, I'm sorry, has to follow this rule starting June 1st. And we actually spent some time on a session talking about this ordinance back when it was implemented, I think within a few days of it taking effect. Short answer to Zach's question is, reading the ordinance, I'm not sure. I wouldn't want to bet a lot from the landlord's perspective that if I'm a managing person versus the actual owner, that it doesn't apply to me if I'm managing 16 or more. But I will say this, the question doesn't matter in 4.5 months, because the rest of the city will be bound to the same rule in 4.5 months. So this is an interesting kind of nuanced question in time, but it's going to be effectively moot when the entire city is governed by the ordinance in a few months. So, and I'm not sure we're going to have a court case before then, because it's likely that that kind of case would be in small claims court. I guess a tenant could, if they're upset about this, could file a complaint through the city, and the city has some enforcement power as well. That's the primary enforcement, actually. And so they could still file a complaint and see what the city has to do with it. But I'm not sure which way they go on that question.
Yep. And that would be a call to 311 in Minneapolis, which I think will eventually get you to Regulatory Services Department, who is overseeing regulation enforcement. Next question. Can landlords demand in-person showings during the pandemic? It's similar to your previous question.
Yeah, it's similar. It's a slightly different take on the question. I think a landlord can ask. What if the tenant refuses, though? If the tenant says, no, you can't come in, and the landlord says, well, I got a key. Okay, I'm going to put the dresser in front of the front door. You can't come in. What is the landlord going to do? The police aren't going to get involved. There's no crime being committed. The landlord can't file an eviction for that reason. It's not endangering the safety of others. It's not damaging property. So I'm not sure what recourse the landlord would have. Now, eventually they could, file an eviction once the eviction order is lifted for interfering with management, I guess, or something like that that might be written in the lease. But right now, I'm not sure what recourse the landlord really has if the tenant refuses an in-person showing. We have lots of clients that are very high risk. I had a client that talked to us the other day, had just been tested for COVID-19. The landlord was insisting on doing an inspection while she's waiting for her test. And she's like, well, I'm not supposed to leave the house, and I don't want anybody else here. I've got maybe COVID-19, somebody else might get it from me. And so she's trying to convince the landlord. And I think that she was successful in that. But I think most people would say, okay, you're waiting for your test. I think I'm going to do my inspection later. And it wasn't something that had some sort of time requirement on it for the landlord. They just like, hey, this is when we do our annual inspections that we do, not they're ordered by anybody. So yeah, I don't think a landlord can successfully truly barge in right now. I think the tenant could actually call the police over that and claim that they're trespassing at that point. We haven't seen the friction that much. Most landlords have said, okay, you know what, we'll start doing video tours when it works. And if we need to make a repair, that's chances are the tenant asking for the landlord to come in. So the friction is lessened somewhat in the last 2 months, I'd say. But in the first 2 months, wow, it was a really knockdown drag out between landlords and tenants on this topic. So we don't get that question and that phrasing much, but it's something that I think a tenant might be able to stop the landlord from coming in. There might be consequences later, but right now it's hard for the landlord to really use any of those avenues.
All right, Sue states or asks, immigrants who file federal taxes with an individual taxpayer identification number, or ITIN, have been deemed ineligible for CARES relief. I'm not sure if that has to do with the extended unemployment that ends at the end of the month, or other forms, maybe all forms. But my understanding, and this might be somewhat related to the announcement last week that Minnesota Housing has received $100 million through the governor's action in handing over some of the COVID 2019 federally funds to create a new rental assistance program. I'm going to put a link to some kind of FAQs about that. That program just got announced. I think applications are due today for administrators, and so the timeline on actually getting the money out is going to be into the next month, as the state decides who the administrators are, which governments, which nonprofit community entities will be the places where individual households apply. My understanding, and I have not been following this as closely as the eviction suspension, is that there's not going to be required questions about citizenship status on this rental assistance fund. But that's what I've heard. But I think there's still still in the process of getting set up, and I'll put the link in the chat. Unless you have anything to add, Mike.
I don't. That's good. Thank you.
All right, I'll add that in just a second. The next question, Brianna asked, with the moratorium in place, can a landlord provide a notice to end a month-to-month lease right now?
Yeah, I don't think they can. And like I said, I think it's a lot more concrete. My answer is after August 4th, too. The governor's new order clarifying that a landlord cannot issue a non-renewal I think really does answer that question. The landlord can't, even in a month-to-month situation, which is just really a non-renewal of a month-to-month. I don't think a landlord can do that. So it seems like that one has been answered finally by the governor's office officially. So I think a landlord in a month-to-month situation that wants to give a notice has to wait for the peacetime emergency declaration to end, and then they can give a notice at that point, whatever notice they might need to give. Again, we don't know when that peacetime emergency will end. We know that it officially runs out on August 12th, but it's been renewed every month since April. So hard to know when a landlord would be allowed to actually give a month-to-month notice.
And Emily asked a fairly similar question. Is it legal right now for a landlord to give a 3-day notice to vacate due to non-payment?
Yeah, well, it is a different question, and I'll tell you where the question comes from. It comes from another state. And I'm not blaming Emily for asking this, because a lot of Minnesota tenants have that in their lease, that there's a 3-day notice requirement if the landlord gives a 3-day notice. Landlords don't necessarily own properties in just one state. They might own properties in multiple states. And we have, in Moorhead, there's Fargo right on the other side. And so there's some Fargo property owners that own property in Moorhead. There's owners that own property in Hudson, Wisconsin, and somewhere in the Twin Cities as well. There's all kinds of border towns where that might occur. And it's not just limited to border towns as well. But in several other states and a few neighboring states, there are 3-day notices to vacate or to terminate or to pay or quit. But Minnesota doesn't have one of those. So this 3-day notice thing is something that we'll occasionally see in a lease. Once out of every, 500 leases that we look at, there'll be a 3-day notice payment requirement, or a landlord only has to give a 3-day notice to make a tenant vacate. But it has no impact in Minnesota law. Landlord-tenant law is, number one, almost all state law specific. And number two, it frequently overrides or supersedes whatever the lease contract might say. And so a 3-day notice to vacate appearing in a lease is probably in Minnesota meaningless. I'd have to look at the actual lease in question to verify that, but that would be my guess almost every time, that there's no real meaning for a 3-day notice to vacate, certainly for non-payment of rent in Minnesota. Nor is there a requirement, by the way. A landlord doesn't have to give a notice that they're filing an eviction for non-payment of rent. They can just, if the rent is due on the 1st, on the 2nd, the landlord can go file the eviction. Now, once August 4th rolls around, we've got that new 7-day rule kicking in, so no eviction will be fileable for 7 days at that point. But anyhow, I get where the question's coming from. It's probably somebody with a lease that was born in another state.
Yeah, and there are some places where a notice is required, mainly in subsidized housing situations. There are certain programs that require pre-eviction notice, but again, during the pandemic, and during the eviction suspension and suspension of landlord-initiated lease terminations, pretty much can't do that. William asks, can I give a tenant on a month-to-month lease a notice to vacate if I want to terminate their month-to-month lease?
Yeah, William, I think we've kind of answered this already, but one thing William did in his question, you guys can't see this because it was submitted in a different area, is he wrote in parentheses right after his name was LL, landlord, which is great. Sometimes we really have to guess whether it's a tenant or a landlord, and I don't think we've ever asked people to do that when submitting a question, but we should from now on because it really makes it easier if you just say that I'm a landlord or a tenant asking the question. Short answer, William, is no. I don't think you can right now give a month-to-month notice to vacate if you want the tenant to go. I think the governor's order, certainly on August 4th, explicitly says you can't.
All right, and we've got a lot of questions coming in. I'm going to take one that came in from the chat. So this is, I think, now related to well, this one might be related to current status, but also on August 4th. Sarah asked, can testing positive for COVID-19 qualify as endangering the safety of others that allows landlords to evict?
Oof. Maybe that's the short answer. I'm not sure how much sympathy a judge is going to have for a landlord filing an eviction against somebody who's just contracted a potentially life-threatening illness. But I guess it's possible that the tenant is endangering the safety of others through their behavior / just contracting the virus, right? I don't think that you have to be especially blameworthy to be endangering the safety of others, just as seriously endangering the safety of other residents. I guess it's possible that a landlord could win that case. I don't think I've seen or heard that case having been filed yet in Minnesota or elsewhere. There might be another case that's already been filed on this, but it would have to be a Minnesota ruling because this is about a Minnesota executive order, and I don't think every state has the same language, if they have any language like that in their executive orders stopping a landlord from filing an eviction. So the short answer is I think it's a possibility. I think if you have a tenant that tests, you could change the facts slightly to make it much more sympathetic for the landlord. You have a tenant that's tested positive for COVID-19 who doesn't believe in masks and walks around with headphones on, singing loudly in the hallways, and is generally just unconcerned about the safety of others, versus somebody who's maybe literally hiding under their blankets for days on end, trying to get better. So I guess it's possible, but again, not sure how much sympathy you're going to get from a judge in that case if it goes that far.
And I have kind of a follow-up. Maybe it's a question. Just both 20-73 and 2079 that sort of added these additional situations explicitly state that nothing in the order creates grounds for eviction or lease termination beyond what's currently provided in Minnesota statutes. And so one of those statutes is 504B 161 that says that in these type of situations, the landlord, it has to be the willful, malicious, or irresponsible conduct of the tenant. So that's maybe sort of down that line of, if the tenant was acting in one of those ways and had the COVID-19, but getting COVID-19, you don't have to necessarily be willful, malicious, or irresponsible to get it, right? So, okay. So then, okay, where am I? Okay, so there's a question in the Q&A. If you're the victim of domestic violence and your ex comes to the property without your permission, is this considering endangering the safety of others on the premises?
So a defense to that kind of situation would be something like this, and this is sort of a pre-COVID-19 defense as well, which is, wait a second, I didn't invite them. They're not my guest. So legally, there's not really a difference between them and some stranger coming to, break doors and throw bricks through windows. And so I shouldn't be held responsible for what they did. Yeah, so I mean, the permission actually matters, I think, quite a bit. Or if they're there and you tell them to get out and they refuse to go, at some point they're no longer a guest. So in general, tenants are held responsible for the actions of their guests. But a key question is it an invited guest or not? And in this situation, I don't think it would be an invited guest. So although the safety of others might be endangered, I think the tenant who's the domestic violence victim would argue, yeah, people's safety was endangered, but it wasn't by me. It was by this person who wasn't my invited guest. That would be the defense. I think it would have a pretty good shot.
And then there's a follow-up question from Amanda, kind of related to this question. I see the question above about domestic violence. It was stated termination for domestic violence. Is that for both parties or just the offender? Would both parties be removed for the violence? Private owners without VAWA?
Yeah. Okay. Well, the original question we got made it sound like it was a guest. Maybe I was wrong about that, but I'm not sure. First of all, there are different rules. VAWA only applies to places where there's a federal subsidy of some type involved. It's not everywhere. Private owners, the main consideration they'd have would be a state law. People with VAWA protection also have the state law that allow a tenant to end a lease early if they wish to for domestic violence. But could a tenant be evicted for allowing domestic violence in their own? I don't know if that's really what they're asking. In general, the victim is not removed. It's usually just the offender, is how the courts eventually sort of wind their ways. That's the result they eventually get to, is the short answer to that question. There's a lot of build your own adventures sort of ways we could go with that hypothetical. Yeah, that's the general answer, is that the victim typically has the right to stay if they wish to. Sometimes they want to get out and they're in the middle of a 1-year lease, and there might be a way to do that.
All right. Emma asks,
did Emma just jump the line somehow?
Yeah, people are voting on it. So I'm going to go to the one that we were, we'll do Emma's
I didn't know
next.
You could do that.
You can. Yes, we're all for democracy here.
Okay.
Anonymous asked, is the 7-day notice, I'm guessing this is within 20-79, paragraph 6, and 20-79 is the one that talks about a 7-day notice. Is a 7-day notice a notice to the courts or to the tenant?
It's to the tenant. That's a fair question. I'm not sure that I explicitly said it, but the order itself says it's to the tenant, not any official court notice that they have to give.
Yeah, and again, paragraph 6 says 7 days or the specified notice period included in the lease, whichever is longer.
Yep.
All right. Emma's has 2 votes now.
Wow.
Regarding 20-79, evictions filed if owner family needs to move in. So that's paragraph 4 of 20-79. Will the eviction show up on a person's record the same way that it would if they had actually violated lease terms? I'm concerned how this sort of eviction might affect a person's future rental prospects.
Wow, that is an interesting question, actually. Okay, so first of all, we're presuming that the landlord had to go file the eviction. The landlord gave a notice saying, at least a 7-day notice saying, I'm moving in or my family member's moving in, we need to move in. And the tenant refuses to go after the 7 days or more, depending on what the lease requires. Could that eviction harm the tenant going forward? Yeah, I mean, look, if a landlord files an eviction, that means a court case is on the tenant's record. I'm not sure exactly how they, for lack of a better word, code that eviction. There's only a couple reasons listed on eviction papers that can be used to file an eviction against a tenant. There's non-payment of rent. There's holding over, where the landlord is given a notice to vacate and the tenant hasn't gone. That's my best guess as to where this would go. There's breach of a lease. There's violating the drug, prostitution, weapon, stolen property rule. I'm guessing it would fit under holding over. Sort of the larger answer to that question is, I don't think that future prospective landlords would necessarily care why the eviction was filed. They traditionally haven't really cared. The question is, has there been an eviction filed against you recently? Whatever number of years the landlord is doing their look back for. And they might sort of weigh the reasons for it or not. Again, almost all of them are for non-payment of rent. But most landlords, if they're actually looking at that, they don't really care why the eviction was filed. They just care that it was filed. So, and I know that's kind of a jaded view, but that's, having done this for a long time and talked to over 200 landlord groups personally, I think that's how they view this, is once the eviction's filed, that's what they care about. They many times, and I think it's fair to say most times, don't really care who won the case. They just care that it was filed. And so an eviction would be filed in the setting that we heard there. So I think that it would have an effect on the tenant's future rental prospects. Maybe they'd have a 2% chance, more higher likelihood of getting that next place they're applying for versus a non-payment of rent eviction. I'm not sure, but I can't make you that guarantee. I would bet against it making much of a difference.
Yeah, and again, regarding this paragraph that Emma raises, it says that there has to be some sort of notice to the tenant, like, well, I or my family member is going to move in. So a lot of this is potentially going to happen outside of the courts, and so it's only going to get to the courts in the eviction if
the tenant refuses.
If the tenant
right.
refuses and holds
Yep.
over. So
Yep.
that's another whole issue is how much of that might occur outside of the court.
Yep.
So Linda asks, excuse me, with mandated masks for all, will entry conditions revert to original? And I just got a strib thing on my phone that says that is official now, that Walz has announced that. And I just noticed that the executive order popped up, 20-81 on the website. So I'm going to try to look at it quick. But
so I don't know what the order says. I've seen some city orders that have come up that actually talk about multifamily residential properties specifically. And so I don't know if that's going to be mentioned in the governor's order, because I'm talking to you guys, so I'm not looking at orders right now. So there might be a requirement that a tenant or anybody in a hallway of a building has to wear a mask. That's what we've been seeing from cities. So if it says that, will entry conditions revert to original, Linda? I think you're asking about, will the landlord be able to come into the place, into the actual specific rental unit of the tenant, like they used to? I think that we still got our COVID-19 concerns there. Certainly the longer the landlord is planning on being in the tenants union, if they're going to do some major work, they're going to be breathing the same air. I think that makes it a slightly different question. But I think we're going to see the evolution of where things are once the order is understood from the governor, and see if it applies to landlords and tenants or not, specifically.
I'll put the link in the chat, and it looks like paragraph 9 of the order is kind of the important part. But
okay.
Yeah. All right. Deborah asks, are all these new rules only good through the peacetime emergency through August 12th? The 7-day notice will go away when the order expires, for example?
So Deborah, that's a really, I'm not sure exactly how you were thinking about that question, but it's one of the clues we look for when we're trying to decide what we think the governor might do on August 12th. Will the governor renew that executive order or not? All right, so we're making a whole bunch of changes to the eviction rules on August 4th, 8 days before the next peacetime emergency declaration decision time comes. Is it really worth it for the governor to tweak so substantially the eviction rules if they're going to just end them 8 days later? I think it's unlikely that the governor is going to be ending them then. But yeah, I think that EO 2079 goes away when the peacetime emergency declaration ends as well. I think it says that specifically. That's what the earlier versions have said. So that's my best guess as to what would happen, is that all the new rules, yep, and that's what it says. Just scrolling down to make sure that it was still in the new 2079. They go away the minute the peacetime emergency declaration ends, which once again is either by the governor deciding to do that or the legislature deciding to do it on their own. Most things that go through the legislature have to be signed by the governor. That does not. All it takes is the two chambers to agree, pure majority votes. But again, both chambers have to agree to end the peacetime emergency declaration.
Right. Another question from Linda. In a more perfect world, who besides police forces, law enforcement officers, could provide security for actual evictions? Could it be pastors, social workers? So yeah, right now it's sheriffs who execute
right
eviction.
Sheriffs, and I think they're allowed to not deputize, but essentially hire police to do that on their behalf as well. It's almost all sheriffs that do this throughout the state, though. So it's not exactly police forces doing it, but they wear a badge and uniform, so they look a lot like police to most people. Yeah, I mean, you could set it up so somebody else is in charge of it. Ultimately, an eviction is, I don't want to downplay what an eviction is. It's the force of the state removing somebody from their home. That's how it's designed. And so, what happens if the person refuses to go is the question. And if, you know, it makes a difference whether they've got a badge and they're wearing a gun in their belt or not. But is that the only way this could be done? No, I'm sure you could do other approaches to it. The question always becomes, what if the pastor doesn't work? What if the social worker doesn't work? Who does it then? And so maybe that's just that they're a fallback, and this becomes a more of a civil attempt. By civil, I don't mean just polite, but I mean a non-military / police approach. But yeah, I mean, you can think that through. I'm sure on some level it's one reason why, there's no way that can't contribute to the general distrust that certain communities rightfully have of the police department, as they might see them as the ones that are enforcing evictions. I am sure that there are 3 or 4-year-olds who their first interaction ever with somebody wearing a uniform and a badge was them removing them from their home, telling them to get their one toy, which is a terrible introduction to the law enforcement system. But that's how it's designed right now. Is there another way it could be done? Sure, but you'd have to change. I think that part of the eviction rules have been around for probably over 100 years. So doesn't mean it can't be changed, but I haven't seen anything significant afoot. It's an interesting question, an interesting theory, and I'm not sure that it's designed the best way possible right now. So thank you for that, Linda.
Right. Is there a dollar amount for significant damage to property?
Really good question. One of those specific types of things that would be great, and I think it's much more quantifiable versus seriously endangering the safety of others. But no, there is no dollar amount listed in the executive order for significant damage. So it's going to be a matter of convincing the judge or referee that what the damage was in fact significant enough to warrant filing one of these pretty unique evictions right now during the COVID-19 protections.
Right. Emma asked, have we gotten any clarity regarding whether landlords can raise rents at the end of the current rental term? Previously, we at Homeline had suspected that would count as an illegal breach of contract.
Have we gotten more clarity? No, that is not really clarified in the governor's new order. I wouldn't say it's an illegal breach of the contract. I think it's terminating the tenancy violation. So I think it's violating the governor's original eviction order along with the current order, but that is in fact terminating the current tenancy by naming a new rental amount. So that is our view still, but we've gotten no new clarity on that, no.
Again, the orders bar landlords from terminating leases. It does not impact the tenant's ability.
Yep. Yeah, tenant can still give a notice to vacate if they want to move out.
All right. Next question is from a landlord with a tenant on a month-to-month lease. As the lease expired the lease went month-to-month when it expired this summer. Landlord is looking to list my house for sale. So I assume that the house is where this tenant is. How do the current laws and governor's orders affect the situation? Will the tenant be able to continue living there through a potential sale?
Short answer is I think yes, the tenant can stay there through the potential sale. I think everybody's locked into this month-to-month lease in perpetuity unless you want to move back in and take possession because you need to, or a family member, or they endanger the safety of others or damage property, or the peacetime emergency gets lifted. I will say I'm not a real estate agent or a realtor, never have been, never will be. But I'm not sure this is the best time to list your place at this point. They tend to get listed during the spring and sold during the summer. If you're generalizing about when the real estate market moves, not all places, but the boat for selling your place this year might have already gone by, at least to maximize your income. If you really want to sell it no matter what, nobody can stop you from selling the place. The new owner, this is the phrase we lawyers use, steps into the shoes of the old owner when it comes to the legal position in a landlord-tenant relationship. So that new owner is probably bound by the same rules, although they might be planning to move in or have a family member move in to that place, and so they might be covered by the new exemption that the governor put in place for August 4th.
Right. And again, reminder, we are going up to 90 minutes today, so we've got another 20 minutes or so if there's still more questions, when there are, and they're still coming in. So Deborah asked, so can you non-renew a lease now for a date after the end of the executive order, let's say August 31, for any of the violation exceptions, good cause in parentheses, I'm not sure.
I think she
Anyway.
means endangering the property or things like that.
And
That's my
any
guess.
of the
Yeah.
allowed exceptions in the new 2079. And then if the household holds over into September, a landlord could proceed with an eviction action at that time.
Yeah, so that's a different question. Deborah's saying, wait a second, can I give a notice for the tenant seriously endangering the property? Let's just use that example, or endangering others. Yeah, I think you can give a notice for that. You probably don't need to give the notice, at least not a full rental period's notice, depending on how your lease is written. You got to give at least 7 days notice to file any eviction once August 4th rolls around. But then should you have to give a new notice, because the notice you're talking about is sort of a traditional standard notice to vacate at the end of the lease or month-to-month lease, a full rental period's notice. That's why you're saying August 31st, I'm guessing. And that's in general not required right now. Again, on August 4th, maybe that new 7-day notice / whatever the notice period in the lease is would mean you'd have to give a full rental period's notice. Yes, I think that clearly the answer to your question is yes. If the household holds over into September, you've given a notice, then you can proceed with an eviction action if it's one of our good cause reasons that we talked about at that point. Yeah, you could file it on September 1.
All right. Are landlords who filed illegal evictions during the suspension being given any consequences whatsoever?
I assume that's a tenant asking that one. Sure, there are consequences. So landlord violates the governor's order on banning evictions or notices, which will take place on August 4th. It's a misdemeanor. It's $1,000, up to $1,000, up to 90 days in jail. The Attorney General's office has enforced this against a handful of landlords around the state. I think they've tried to use example cases where the behavior of the landlord is pretty egregious. The Attorney General's office, I think, Eric, you mentioned that you were on a conference call today. They said they've now hit the 1,000 call mark or 1,000 complaint mark this year on this. Is that right?
They've had over 1,000 complaints specific through the eviction, on evictions. Obviously, they're getting other types of complaints like price gouging, et cetera, but over 1,000 just on eviction now. Right.
So there are consequences to landlords. I think the most common consequence is the Attorney General's office calls the landlord and says, you can't do what you're doing. I actually, when I was in law school, I spent a summer working for the Attorney General's office in Massachusetts, and I had to call a lot of people in that job, and most of whom were not opposing the state or in trouble. I was just actually gathering factual information. And I would call people up and I'd say, this is Mike, I'm calling from the Attorney General's office. And the fear that you could hear in people's silence was impressive, honestly. It was really strange, that power of that phrase had to just make people concerned. And so the Attorney General's office calling up a landlord saying, hey, this is what the tenant told us you're doing. Is that right? Well, you can't do it. And if you don't stop, we're going to come down on you. That convinces most landlords to back off. I will say that in recent, not even weeks, but days, we have suddenly seen a surge of price gouging questions from tenants. So again, the governor's issued 81 orders now, it sounds like. One of them prohibits price gouging for essential services. Housing is listed as one of those essential services. And price gouging is defined as any increase of 20% or more. There's another definition that might be less than that, but 20% certainly is a rule. And had 3 of those cases in the last, I think, 5 days I've been on the phones where tenants have gotten a more than 20% increase. The penalty for the price gouging violation is $10,000 per violation. So I'm not sure if the Attorney General's office will actually go after the landlords in those situations, but they might, and they have some footing to do so. So there are some serious consequences that are out there.
Yep. And in addition to the enforcement under the order, it also says they can seek additional relief under another statute, a broader Attorney General statute, Section 8-31. All right. Rome is asking, can a landlord force a tenant to sign a new 1-year lease right now?
So built into that question is the concept that we've got a tenant that's been there for a year at least, probably before. The renewal period has come up and the landlord says either sign a 1-year lease or else. The question is, what is the or else? Most leases become month-to-month leases if the tenant sticks around past the day they were supposed to leave. So they were supposed to be gone by June 30th. They're still there on July 1st. The tenant pays their rent on July 1st. The landlord accepts it. It becomes a month-to-month lease in most situations. Can a landlord force a tenant to sign a new 1-year lease right now? I don't think so. I think that would be terminating the prior lease, or the pre-existing lease. I think the landlord and the tenant are both stuck with the month-to-month. Now, if the landlord wants to offer a new 1-year lease and the tenant wants to sign it, that's a different question. But forcing it on the tenant, I think, is an easier one to answer. I don't think the landlord can require it.
Okay. What happens twice? I think this question came in when we were talking potentially about the
If the tenant has
domestic.
COVID-19?
I don't know if it was that or it might have been the domestic violence situation. I'm not sure.
I don't know the answer to that one without more info on that one. So
we'll leave it open, and
yep.
if anybody can clarify, that would.
Natividad, I believe, is how you say that.
Yeah.
If you could just clarify the question, that'd be great. We'll try to answer it.
And then I got one in the chat that came through, and that is from Hillary. Hillary is an owner-occupying landlord in a duplex. Hillary learned I would not be able to make it into a triplex without a sprinkler system until right after quarantine started. So I've been without a kitchen for a while. My understanding is that now I would be able to give my month-to-month lease tenant on another floor a lease term because I plan to move into that unit, right? Okay.
Okay. Oh, yes. All right. So she's saying I want to basically give somebody else a notice to vacate from their unit in the same building that I'm living because my unit is unlivable basically right now because I need to move in. First of all, Hillary, you can't do that until August 4th. That's when that rule takes effect. You certainly don't have the right to do it before then. And then you'd have to give at least 7 days notice, maybe more, depending on how your original lease is written. But yeah, you might be able to do that. I think that would fit your situation, is that might apply to you.
All right. If the landlord asks to make an agreement with the tenant that if the tenant leaves, no past rent is due, is this allowed or is this a termination of a lease, even in a month-to-month context?
Okay, so I think this is a question about a cash for keys kind of situation. Is that what you're gathering, Eric?
I think so. Yeah. I mean, yeah. I think it's
that's what it is, right?
Some sort of an agreement that because.
Yep. Okay, so I'm going to put numbers in here because it's going to help me visualize what I think the question is really asking. So the landlord makes an agreement with the tenant that if the tenant leaves, no past rent. Let's assume for a second the tenant hasn't paid rent since March. So they owe, using our $1,000 a month standard rent, they owe $4,000, right? And the landlord says, if you leave, I'm going to wipe out your debt. And is that okay for a landlord to do that? Yeah, I think it is. I think it's okay for a landlord and a tenant to work out an agreement for the tenant to vacate in exchange for the landlord waiving the $4,000 in rent. I think they'd be able to do that. Yes.
I mean, it has to be
I'm certain that's happening.
Yeah, it has to be a mutual agreement.
Yes.
It can't just
be forced on the tenant.
Yeah. Okay. Abigail asks if the landlord filed an eviction illegally and the Attorney General confirmed that it was illegally filed, does the AG expunge the eviction from the tenant's record?
Well, the AG does not have the power to expunge the eviction from the tenant's record. These are court files. The Attorney General's office does not control court files. They can make recommendations about them, but they don't control the court files. So something else would have to happen. The court has to decide ultimately to expunge a record, or there has to be some sort of legislative edict somehow making that happen. I suppose could happen as well. But we really do try big picture wise to separate out the functions of the branches, right? The legislature makes the rules. The governor is supposed to enforce those rules. And then the court decides what the rules might be. But court rules in general are governed exclusively by the courts. Now, legislation can be passed to instruct or recommend things for the court, but in the end, the court ultimately decides what to do with their records. So I don't think that there's going to be an automatic expungement if a landlord files an eviction illegally. I think it's, well, I would never guarantee anybody an expungement. It's a pretty good bet they're going to get an expungement if the eviction was filed illegally during the COVID-19 pandemic when everybody understood, especially if the AG's office was involved, which means that it was probably a misdemeanor for the eviction to be filed. So I'd really bet strongly on the eviction expungement, but I would not promise it to a tenant. And I certainly wouldn't expect that it just occurs naturally. We heard from Referee Hoteling last week that she wasn't sure exactly what would happen with evictions that were filed illegally during the COVID-19, that they had been marked as confidential. She seemed to be implying that they would be removed. I can't make you that guarantee throughout the whole state. And I'm going to want to see that before I believe it is actually occurring. But maybe some of them will be removed depending on which county and which court is looking at them. But if I were a tenant and the landlord filed an eviction against me right now, illegally, when the governor's order is in place, and I was looking for another place once the order was lifted in a year or something, I would certainly be checking to see if that eviction was still on my record. And if not, I'd be filing a motion for an expungement.
Yeah, I was going to say Referee Hoteling did kind of talk through what Hennepin's doing, and so you could watch our webinar and jump ahead to that part because it did get into some details about what they're going to do. But again, that's just going to be Hennepin.
Yeah, that was county specific. Yeah, yep. I think that's right.
And like you said, I think other counties might follow, but it is going to be potentially on a county by county basis. It may also just be in the slides, which is on our website. That's all that I see in the Q&A box. I did realize that there was maybe a handful more questions that were in the Q&A box from last week that we didn't get to, and I have them up here. But if anybody does have any other questions, go ahead and submit them. Otherwise, are you okay doing these other ones? Or
yeah, whatever you got. Let's hear it.
All right. Can a landlord? This got answered, I think, today. But can a landlord demand in-person showings to buyers during the pandemic?
Yep, we did talk about that one.
Yep. Can a landlord show up unannounced?
Oh, hey, that's a new one. Hey, look, the landlord can always knock on the door, right? They can knock on the door and say, can I come in? The difference between a landlord and me, for instance, I'm not a landlord. If I knock on somebody's door unannounced, the tenant can say, I don't know who you are. I don't want to talk to you. Get away from me, right? And then I got to go. But the landlord has a key. That's the difference between me and the landlord. And so when the landlord can use their key is the real question, which there is a state law that's been around since the mid-90s that tries to answer that. Like I said, we've got some COVID-19 specific concerns, but showing up unannounced, there's no law against them knocking on the door. It's when they decide to use their key. Then they're supposed to give advance notice, reasonable notice under the circumstances, and they have to have a reasonable business purpose when they use their key. But knocking on the door, they can do that anytime. It's not illegal. It's just the tenant has the right to say no thanks.
All right, then there's a question. Can a landlord, when renting, ask for first and last month rent plus a security deposit? And this might be specific to Minneapolis. I'm not sure.
So we're entering a new era, in my mind, of landlord-tenant law in Minnesota. And I'm not sure how deep this well is going to go. It's hard to know right now. But I think when the history of landlord-tenant law is written 100 years from now, we might be entering the city law era at this point. Minneapolis has enacted some rules about how much of a deposit can be collected by a landlord. St. Paul has some that are going to start next March. And I imagine other cities are going to follow suit, probably metro specific cities at first, and it might spread. Why is this happening? Well, city officials can pass their own rules. That's the basic rule. They don't have to wait for the state to come up with their own rules. Things that have been proposed at the state level for, well, decades, frankly, tend to get shot down fairly regularly in the landlord-tenant arena. We could spend a lot of time, but people would be bored about that, and it would get probably unnecessarily political to go into it. But new rules at the state level simply don't thrive in landlord-tenant law much. They have a hard time getting to where they want to go, at least where tenant advocates want them to go. At the city level, tenant advocates are having more success, and tenants themselves. Minneapolis and St. Paul are both renter majority cities. That means there are more people living in those cities that rent than own their own home. And so those people are voting. They're voting in elected officials that use renting as a platform plank. And so they're specifying that. So this question is really about that. I think that's what they've been hearing. And the short answer is maybe, depends on what city you're in. There might be a limit on how much the deposit can be. So there you go.
And earlier I did link to the City of Minneapolis page that has info and links to the deposit and other ordinances on there. And we got a live question. Can a landlord enter without notice if they bring police with?
I don't think it changes the landlord's footing legally to go in, that the police are along with them. They're still bound by the same landlord-tenant laws that they always are bound by. So they're supposed to give reasonable notice. I suppose on some level they could argue that there's some sort of emergency factor, and it's going to hinge a little bit on what's actually going on. Are they suspicious? There's a concern about a gas leak and the police officer happened to be wandering by. I think the landlord can barge right in. But if the police say, let me in, well, then we've got Fourth Amendment concerns as well as the landlord-tenant protections that a tenant might have. So landlords don't like that spot, by the way, where the police say, you need to let me in with your key right now. That's a tough constitutional spot for a landlord to be in. And it doesn't happen much where the police will insist on that. It does, but not commonly.
Okay, a couple more, and then I'm also going to put up again on the screen. I put a link in the chat to next week, and in a second I'll put up the info on it. Yeah, this next question, we sort of got to it already. Will improperly filed evictions be dismissed at the first appearance, even if the tenant does not appear? There's also another one that's very similar. For improperly fired or those in violation, will they be removed, or will the tenant have to proactively do another expungement themselves down the road?
Yeah, so I want to point out one thing there. Somebody's referencing a dismissal. Will the case be dismissed? Dismissed is not the same as expunged. Dismissed means that the case was essentially found defective in some way, or neither party showed up or something like that, and the judge said, you know what, case is over, we're done with it. But an expungement is where the case actually gets removed from the court records, erased, deleted, however you want to phrase it. Much more favorable for the tenant. It won't show up in a background check, whereas a dismissed eviction would show up. So simply getting the case dismissed doesn't accomplish what the tenant really wants. I mean, they don't have to move out, but they have an eviction on their record still. Will these automatically be expunged? I can certainly see a possibility of that. Maybe a governor's order could make that happen, or some legislation that could make that happen, or the courts could just unanimously decide to go in that route, like we seem to think Hennepin County was at least considering, and maybe that was where they were going to go with that. But I would not count on an expungement until I see it removed from the court database. That's when I'd know it's gone.
All right. Well, it's 2:59. Do you want to do one more pitch for next week, and then we'll call it a day?
Absolutely. So once again, I'm excited about next week's speech because, as Eric likes to point out, I'm sure a lot of you are tired of listening to me talk a lot, not quite endlessly, but it seems like that some of the time. So I'm really happy to have a guest of any type, but Kim really knows what she's doing. And she's going to be talking about the landlord attorney perspective, talking about what she's telling her clients now, what she thinks she's going to be telling her clients when the eviction moratorium inevitably gets lifted, whenever that might be. So I think it's going to be a fascinating session. I'm sure we're going to get a lot of questions in advance, and hopefully an interactive and upvoted upon question and answer session as well.
All right. Well, looking forward to next week on that. And thanks everybody for joining us today. And we hope to see you next week. I think if I did it right, there is a link in the chat, but I think when I hit stop on this, Zoom is gonna automatically zoom you straight to the registration for next week. So maybe we'll see you next week. And otherwise, have a good rest of your day. Thank you.